and the other one that needs to be filed together with the renewal of the registration. The modification that is incorporated in this new law is that IMPI will issue an official action if the declaration of use is not filed at the moment of requesting the renewal. If this declaration of use is not filed, IMPI will issue the official action granting the owner of the registration 2 months to file this declaration of use, which is very important, especially for those applications and registrations granted derived from the Madrid Protocol, because many of trademark owners were not aware of the need of file this declaration of use together with the renewal of the registration, which unfortunately had the consequence of abandoning the trademark registration even without the knowledge of the trademark owner. Next, please. And well, another relevant modification, and the last from my side, is that linked mark or associated marks can be dissolved. This association can be dissolved for the purpose of assigning just some of the marks and not all of the marks. In the past, in the previous law, if linked or associated marks were assigned to different entities, this was not possible, and we had no a legal mechanism to unlink this association. However, now we will have the possibility to file a letter of consent between assigner and assignee in order to dissolve this association, which is very important, especially for trademark owners or corporations that would like to assign some of the mark to different entities for business reasons. And we will have this mechanism with the new law, and of course the examiner will have the decision in their hands in order to decide whether or not they assign these associated marks. And well, this is all from my side. Thank you very much for being here with us. And Alonso, I give the word to you.
Thank you very much, Wilma. Needless to say that from these changes pointed out by Wilma, the change in the term of protection of a registered trademark will be an extremely important task for trademark owners and legal practitioners in order to properly docket the renewal due dates in their databases, depending on the law governing the life of such trademark registrations. Now is the turn of Sofia Arroyo, Senior Associate at our Prosecution and Enforcement Practice, who has been a pioneer with respect to the use of the opposition system in Mexico, and who will explain the most important changes in oppositions. Go ahead, Sophie.
I think we cannot hear Sophie.
Sorry for this technical issue. Can you hear me now? Okay.
Yes, go ahead.
Thank you, and sorry. Good morning, everyone. Now, one of the most important changes in the opposition proceeding will be the one you are seeing right now. That is that the term to respond to an opposition will be 4 months after the opposition has been served to the applicant. Now, this change is significant because in the prior law, we only had 1 month to respond to the opposition. And the reason for this change is involves a greater change within the law. The law now aims for the examiner to issue only a single official action during prosecution that includes formal requirements, absolute and relative grounds of refusal that the examiner may have determined during their own analysis of the application, and notify all the oppositions that have been filed against this application. Since all of this information will be served through a single official action, and the term in the law to respond to official actions is 4 months, then automatically the term to respond to the opposition will be extended to 4 months rather than 1. Now, this is good in the sense that it will make the prosecution of an application, it's aimed at making the prosecution of an application, the time involved to make it shorter. However, it does create a disparity among among the opposers and the applicants, because the opposer only has 1 month to file the opposition after the application has been published, but the applicant will have 4 months to respond. Now, next slide, please. Now, if another relevant change that will also be addressed further down the line will be more addressed further down the line in this presentation, is that if an opposition is filed, the opposer will now be precluded from later filing an invalidity action on the same grounds and arguments as the evidence used, and with the same evidence used in the opposition. This is if the opposition, if, for example, we filed an opposition based on likelihood of confusion between 2 marks, then we will not be able to initiate an nullity action based on likelihood of confusion against the eventual registered mark that we opposed initially. Next slide, please. Oh, now, another relevant change in the opposition proceeding is that the term to file allegations is now 5 days. Now, 5 days is a very, very short term. However, it's a little bit better than it was before because it was only 2 days. So, and the final relevant change that I will be talking about is that when the filing date of an application changes, then this application will be republished again for opposition purposes. This is a significant change because in the previous law, this was not clear in the law, and there were conflicting interpretations in this subject, even among the authorities at IMPI. So, but now the law has solved that problem and has clearly established that if the filing of date of the application changes for any reason, that one example, for example, is when we enlarge the number of products that were covered with respect to the initial application, then the application will be republished for opposition, just as if it's a new process. Well, that is all for my part, and we go back to Alonso. Thank you very much.
Thank you, Sophie. There's no doubt that the fact that an opponent will be precluded from filing a cancellation action under the same merits on which the opposition was filed is one of the biggest downsides of this new law. However, within our firm, we have been discussing this topic in order to find alternatives for our clients to manage this situation with creative solutions. This is the reason why we have invited Alejandra Vadillo to be our last speaker within this panel, so that she may provide her input on this issue as an experienced litigator within our enforcement practice, and also to talk about additional changes in the administrative litigation proceedings associated with trademarks in this new law. Thank you, Ale. You may now start with your presentation.
Thank you very much, Alonso. Good morning, everyone. Well, relevant changes in connection with trademark litigations were made in the new federal law for protection of the industrial property. Since in the previous webinar, these changes have already been explained, in this case, we will focus only in 3 changes that are closely connected with what has been explained in this webinar. And these changes are number 1 is oppositions and invalidity actions. If an opposition is filed, the opposer's prerogative to file an invalidity action at a later stage against the adverse trademark, once registered on the same grounds, arguments, and evidence used in the opposition will preclude. This means in the former law, we had the option to file an opposition during the prosecution of a trademark application. And in case the opposition did not prevail, we still had the opportunity to challenge the validity of the new registration. However, the new law states that invalidity actions will not be admitted if they are based on the same arguments and evidence submitted in the opposition proceeding already solved by IMPI. In my opinion, this is an unfortunate change from a legal perspective that will have a negative impact in our legal system, because in those cases in which an opposition has been filed and the same was not successful, it will not be possible to further try to invalidate the conflict registration using the same arguments or causes of actions and evidence, making meaningless the invalidity causes of action designed specifically to attack registration granted by error by IMPI. Next, please. Thank you. The second point is introduction of partial non-use cancellation actions and partial invalidity actions. I'm going to start with partial non-use cancellation actions. With this new modality of non-use cancellations, the Mexican Institute of Industrial Property will be empowered to declare the cancellation of the registration either in its entirety or in connection with specific products or services that are not in use. This new modality of non-use cancellations will have a positive impact in our legal system, since it was very common to file a trademark application covering the heading of a whole class, even when the trademark was not aimed to be used to identify all those products or services. Situations that create a multiplicity of obsolete registrations that block the possibilities of choosing a trademark for those who were interested in using it effectively. Therefore, by being able to declare the partial cancellation of a trademark registration in connection to those specific products or services that are not in use, a public order function will be fulfilled by cleaning IMPI's trademark record, allowing it to be a faithful reflection of the trademarks that are effectively used in the Mexican market. The downside of this new modality is that it cannot be enforced against registrations granted with the former law, which in my personal opinion is a mistake, since I believe the aim of this amendment was precisely cleaning IMPI's trademark record from all registrations. The second point is partial invalidity actions. In this new modality of invalidity actions, the Mexican Institute of Industrial Property will be empowered to declare partial invalidity actions exclusively in connection with the products or services covered by the trademark registration and not over the elements conforming the trademarks. This new modality of invalidity actions will also have a positive impact in our legal system, since it provides more legal certainty to trademark owners who will not be facing the risk of suffering the loss of their trademark registration in their entirety for the mere coincidence of similarity or of one or two of the goods covered by their registrations. In case a trademark registration is partially canceled, a marginal annotation must be established in the certificate of registration, in which the modification to it shall be stated, as well as the reasons that caused such modifications. Now, although there is no express provision in this regard in the new articles on partial non-use cancellation actions, since this was established in the new provisions on partial invalidity actions, it will be expected that IMPI eventually clarifies that this provision also applies in relation with partial cancellations. Now, finally, the new partial actions can only be brought against the registrations that were applied for and granted under the new IP law. Next, please. Thank you. And the third point is invalidity cause of action based on falsa data. The invalidity cause of action based on falsa data was modified to only sanction now the lack of veracity or in declaration of date of first use contained in the trademark application format. And it is expressly indicated that the burden of proof is reverted to defendant. Thus, Since a trademark registration can be annulled if the owner of the trademark is unable to demonstrate the truthfulness of the declared date of first use during the corresponding nullity proceeding, it is advisable to declare the date of first use as long as documentary evidence is available to sustain such a declaration. From my part, that's all. Thank you very much. We go back with you, Alonso.
Thank you very much again, Ale. As you can see, through these new partial cancellation and invalidation proceedings, this law provides additional tools to remove obstacles for registration of new marks. It will be very interesting how they start working, and we are looking forward to see the results of these changes, although they have limitations. There's no doubt that it is a better scenario than what we had in the past. Likewise, bearing in mind that the legal effects of an opposition of a cancellation action are different, a good assessment as to when or how to oppose versus to waiting to file a cancellation or invalidation actions will become crucial in order to meet trademark owners' specific needs and expectations. And now we will move to the section of questions, and any question you may have is welcome on the general chat. I see here a question that says, the validity period of international registrations designating Mexico will be modified, derived from the provision in the new law. I think, Wilma, you can address this question.
Yes, no, it will be not modified because, as you know, the validity of an international registration is counted as from the date on which WIPO receives the application for international registration. This is very important, especially for us, for our internal files and deadlines, because in this case, we will have two different dates. In the case of international registrations, this will be counted as from a filing date, and in the case of Mexican registrations filed locally will be counted as from the granting date. In this case, it will all legal requirements for international registrations remains the same.
Excellent. Thank you very much, Wilma. There's another question that said, is it mandatory to indicate the applicant's personal email or a corporate email in the application forms? Or would it be possible to indicate Olivares' email? I think this is also yours, Wilma.
Yes, fortunately, it will be possible to indicate the representatives or the agent's email, and it is not necessary to indicate a personal or not a corporate email, so we can, as representatives, receive all communications from the office.
Excellent. Thank you, Wilma. There's another question here. What is more convenient to file an opposition or to file an invalidity action? In other words, what are the advantages and disadvantages of each proceeding? Sophia, I think this is something that you can address.
Yes, thank you. Well, a short answer to that, there's a short and a long answer to that. The short answer to that is the one that no one likes, is that it depends on the case. I mean, actually, the situation needs to be addressed on a case-by-case basis because, well, in general terms, both proceedings have their advantages and their disadvantages. In the case of the opposition, for example, if you manage to file the opposition and be successful in the proceeding, you can stop a potential conflicting trademark that can cause you problems in the market from ever becoming a trademark registration, and that this will allow you to proceed with enforcement and infringement proceedings as soon if the applicant uses the mark without registration, without having to wait for anything. However, given this limitation of not being able to use the same arguments and evidence for a posterior nullity proceeding, the situation needs to be addressed on a case-by-case basis. Because in cases when you need more time, or the analysis is more complicated, or you need to reinforce your evidence, or you are not sure, for example, how great the possibilities of an opposition are, it may be convenient to consider the possibility of filing a nullity action, of waiting to see what happens with the opposition, with a trademark prosecution proceeding, and depending on that, filing a nullity action. It's again, it's I think that a thumb rule, I think I would recommend to consider opposition as a first option when the chances of opposition are good, and consider the convenience of waiting for the possibility of a nullity action when the chances of success in the opposition are borderline or not so good. And I don't know if Ale would like to chip in on her side for this situation.
Yes, Sophia, I think it will be necessary to analyze case by case in order to provide the best line of action to clients, bearing in mind the pros and cons of each line of action.
Excellent. Thank you very much, Ale. Thank you, Sophia. We have another question here. Well, these are two questions. The requirement of informing an email, should it be client's email or agent's email? I think Wilma has already addressed this question. And there's another one who says, why filing date may be changed? Wilma, can you tell us?
Yes, I think this is related to what Sophia was saying about the republish of a trademark application. As Sophia was mentioning, IMPI, there are some cases in which IMPI can republish a trademark application for several reasons. One of these reasons is that the trademark, the distinctive sign per se, is changed. For example, if you file a word mark and afterwards, for some reason, you file an additional read before IMPI, and you change the word mark for a design mark or a word design mark, then the filing date is changed, and the application will be republished once again for opposition purposes. Another reason, for example, is that you change completely the description of goods or services, and in this case, also the filing date will be changed, and the application will be republished for opposition purposes. I don't know, Sophie, if you would like to add something else.
Well, not really. As far as I understand, the only two causes for the changing of the filing date, it's precisely the ones you've already mentioned. That is the change in the distinctive sign and the change in the scope of protection of the mark, because it's understood that the change of protection of the mark, the scope of protection of the mark is understood in the two cases you mentioned. So that's why the application is republished and considered as a new application.
Yeah, that's right. That's right. So let's go to the next question. It says, regarding new partial non-use cancellation actions, does this mean that we will need to prove use of all the products or services covered by the registration? Ale, I think this is one for you.
Thank you, Alonso. No, the current criterion applied by IMPI remains the same. This is if the use of the trademark is proof in connection with any of the products or services covered by it, the cancellation will be denied. With the new partial non-use cancellation, it would be necessary to establish in the claim that you are requesting a partial non-use cancellation action in regard with certain products or services covered by the registration. So in this case, it will have to be specified in the claim that you are requesting a partial non-use cancellation action. Of course, we will have to keep in mind that these actions can be enforced only to registration that were applied and granted under the new IP law. Thank you, Alonso.
Thank you, Ale. There's another question here. It says partial invalidity actions will apply to all the causes of action provided by the law. I think this is also yours, Ale.
Thank you, Alonso. No, partial invalidity actions can only be brought in regard with two causes of action: prior use in Mexico or abroad, and prior existing registrations. That's only the two causes of actions that apply these kind of partial actions.
Thank you, Ale. There's another question here. Considering these new changes, is it better to file national trademark in Mexico or an international trademark designated in Mexico? Well, this is a very interesting question. We have been discussing a lot this with our clients. I think I will not anticipate that. I think that probably Sophia can give us a little of what we have discussed about this situation. You can respond to this question.
Yes, thank you, Alonso. Well, this is an interesting question to answer, as you mentioned, and it is also it's also one of those cases that, well, it depends. It needs to be analyzed on a case-by-case basis. Certainly, the changes, for example, in the form in which the validity of the trademark will be counted now are significant. So, for example, if you expect to have a long litigation process or a litigation process to be able to obtain your registration, it may be convenient to file locally, and then in any case transform the eventual national registration to associated with the international registration once you have obtained the registration. Because if the litigation goes long for a few years, for various years, that litigation proceeding will not be eating into your validity until the time of will not be eating the time of validity of the registration. However, if you expect to have a smooth proceeding, you may want to go through Madrid. Likewise, if you are filing in multiple countries and have a situation where it is easier for you to handle the application through Madrid, well, then maybe you should go there. But also, if you have, for example, one difference between Madrid and the local filings that we did not mention here, because it's not a change in the law, but it's something that exists even from the previous law, is that locally, by filing locally, if you have been using the mark in Mexico without registration, if you file locally, you can claim a date of first use, and that grants you certain protection, because in the case that someone wants to invalidate your registration, for example, based on prior use, saying that they have to demonstrate prior use, not prior to your filing date, but prior to your declared date of first use. And this declaration of use cannot be done if you file through Madrid. So if you've been using the mark for 3 or 4 years, you lose that protection if you file through Madrid. So again, there are multiple combinations in these cases. I've just made a few examples of what we can face, the more common examples we can face. But again, it's a case-by-case basis. I think that's well. Thank you.
Additionally, Alonso and Sophie, also one of the differences is the time that takes for IMPI to analyze an application for an international registration that is received from WIPO, because IMPI has 18 months to analyze and examine an issue whether the certificate of registration or a provisional refusal, while if you file the application locally, IMPI will rule in only 4 months, and this is a very important difference between the two systems.
Yeah, that's absolutely right. So let's move to the next question. It says, if a declaration of use is not filed within 3 months after the third anniversary, the IMPI will issue an office action or the trademark will automatically be declared as abandoned. I think this is yours as well.
Yes, unfortunately, the possibility for IMPI to issue an official action is only recognized for the declarations of use that are not filed together with the renewal application of the registration. If the 3rd year anniversary declaration of use is not filed, IMPI will not issue an official action, and therefore the mark will be declared as abandoned.
Now, if I may jump in this, it's not related to the declarations of use, but it's related to a situation we have detected with the trademarks that are granted through Madrid. When IMPI grants a registration through Madrid, the 3rd year anniversary declaration of use is counted as of the date in which IMPI grants the registration. However, the notice of grant or the notice they send to WIPO to let applicants know that the registration has been granted is issued with a posterior date than the date in which IMPI actually grants the registration. So since through Madrid, applicants are only receiving the notice of grant issued by IMPI in a posterior date, we have noticed that sometimes there's 1 or 2 months of difference, but we have even seen cases in which there's 11 months of difference between the date in which IMPI actually granted the registration and the date in which they sent or they issued the office of consent to WIPO. And this is important because the term if you follow for those that file through Madrid, if you follow the date of grant that you received from WIPO, you do not have the correct date for filing the 3-year anniversary declaration of use, because it's different. It's always posterior, and that is an issue that needs to be addressed promptly.
Yeah, that's right. Thank you very much, Sophie. We have a couple more questions. By the new IP law, if it's possible to use or combine 2 trademarks together, and in this case, what are, in your opinion, the rules to use? I don't know if I understand correctly this question, but I think that it's what happens when you use 2 trademarks together and under which rules you can use them in order to be a valid use of each of the marks separately. I think that's what I understand, but probably Wilma, you can respond to this question.
Yes, actually, the new law has no difference as of the use of 2 combined trademarks. As long as the trademark is used, if it is together with another trademark in the product or to identify goods or services in the market as it was registered, or with modifications that do not alter its distinctive character, IMPI should consider this use as a valid use of the trademark, and therefore the mark will not be subject or will not be cannot receive non-use cancellation actions from third parties. I don't know if Ale and Sophie agree with this.
Well, no, I think I agree with you completely. I mean, each mark will be subject to the same rules of use that we have always had, and you can use them alone or combined with others. For example, the easier example is when you have your logo and your name mark filed as different separate trademark registrations, and you use them together. That's perfectly acceptable. It's perfectly correct, and the authorities will consider that a correct use of the marks.
Yes, that's correct. I don't know if these answers responded to the question that was made by someone at the audience, but there's also it is important to point out that although the Mexican law does not expressly recognize serious marks, as it happens in Europe, where several variations of the same mark can be protected through a single registration, with this new definition of trademark that we have, the doors are open to try to experience, to try to make a try to try to protect this kind of trademark. So yeah, we're every day trying to innovate and to bearing in mind that the new law does not limit the protection of trademarks to visible signs, but to all signs that can be perceived by the human senses. I think it is possible to try to protect this trademark, even though not expressly mentioned in our law. And we have a final question because we're still in good time, but we have another question here. It says, based on these changes, those trademark owners will need to choose between oppositions and invalidation actions. What would you recommend? I think, although we have already addressed this issue, maybe Alejandra, Sofia can elaborate a little bit more about what's the situation.
Yeah, thank you, Alonso. Well, I think it will be necessary to analyze case by case in order to provide the best line of actions. I mean, if the positions has pros and cons as well as the invalidity actions. So I think it will depend in the case and the details of each case in order to know which is the best option for client. I don't know if you want to add something, Sophie?
Yes, just that aside, also after analyzing on a case-by-case basis, we are actually analyzing alternative possibilities to find a way, to see if we can find a way in which we can be able to file the opposition and also file the nullity action. For example, maybe filing I mean, this is only being analyzed. It's not for certain, but one of the oppositions that we're working with, one of the options we're working with is the possibility of filing the oppositions not on behalf of the trademark owner, but as individuals, for example, so that the trademark owner then has the possibility, because the Mexican IP law doesn't limit the filing of the oppositions to the trademark owner. It actually can be filed by anyone. So that's one of the possibilities we are analyzing. It's not still, it's not yet something that we are have determined yet, but we are analyzing alternative possibilities to try to find a way in which we can somehow preserve these two options to our clients.
Yeah, that's right. Well, we will have to be creative. I think that again, bearing in mind that the legal effects of an opposition and of a cancellation action are different, we should try to find the way to offer to our clients both alternatives in some or other way, depending on what is the goal of filing an opposition, or what is the goal in preventing registration of a mark or expunging a trademark already registered from the register. So I think that's all the questions that we have now. And well, I would like to thank you again for joining us today. We sincerely hope that this webinar has met your expectations. And please feel free to send us emails with any additional questions you may have. I would like to, don't forget that to sign into our today's last webinar regarding patents, which will start in 12 minutes. So thank you again for joining us, and have a good, wonderful day.
Thank you.
Thank you very much.
Thank you very much.
Goodbye.